Okay, I'm starting to stream. Okay, it's live now. Where should I tell people to go? Yeah, I can go to the page I'm on right now so they can have that. Page I'm on. Bye. Okay, hopefully I don't have too many of you on this email watching me try to get everybody else involved. All right, we'll try this again. I apologize for the delay and the technical issues that we were having with YouTube. It's really not YouTube's fault. We use a program called OBS, and they just updated, and there was a little bit of a glitch in the software. So my apologies. So let's begin again. I'm Guy Shir, Shir Law Group, and I'm here today to discuss with you the recent openings by our great governor of the state of Florida, where he has opened up now the state to phase 3 situation. And I'm going to go ahead and read you a little bit of the order that he issued. It's Executive Order number 20-244. And again, during my video, I may be looking around at different monitors to be able to give you really a good feel of what's going on, and you know, so you can ask and look at any questions that you may have. I'm also going to have a live chat that should be available for you to start asking questions. As you can see, I'm wearing a mask, and the reason I wear a mask, and everybody has their own reasons, but the reasons I wear a mask is because I'm concerned about my health, welfare, and safety, and I want to shield myself from people who potentially either have it, may be asymptomatic and not be aware of it. So I wear my mask for that reason. I also wear my mask because I care about you and the people that I pass by, whether it be at Home Depot, Publix, or whatever other retail store I visit, or even walking here in the hallway. If somebody comes by me who's passing in the hallway, I want to make sure that, God forbid, if I have it, or I'm asymptomatic, that I don't transmit it to somebody else. Having said that, I'm here in my office, and obviously there's nobody here, so I'm able to take off my mask. So the governor issued his order earlier this week, and the order is called a right to work business certainty suspension of fines. And what he basically addresses are a number of issues. First of all, restaurants. And he says that local governments cannot limit restaurants to less than 50% of their indoor capacity. But if it is limited to less than 100%, there needs to be some type of justification quantifying the economic impact of each limitation and explaining why the limitation or requirement is necessary for public health. Also, suspension of individual fines and penalties. So all those actions taken by, and I'm really concerned more because I practice primarily here in Palm Beach, Broward, and Dade County, the actions taken by our local governors and governmental officials, including, I know Miami Beach was very active in some of these matters, in potential fines for people not wearing their masks and not taking care of themselves. So as a result of all of this, the governor has now basically said municipalities or county orders cannot now fine people for not wearing a mask. He does clarify to some degree, and it causes, I think, more confusion. Nothing in this order preempts or supersedes a non-COVID-19 municipal or county order. Okay, so obviously a non-COVID, and nothing here is really having to do with non-COVID issues, but I guess he's wanting to make sure that counties and municipalities are aware that they have their otherwise full rights of passing ordinances and so forth. How does that affect all of us? Well, one thing I want everybody to recognize, and I want to go back to an example I've used many times in the past, architectural control, something that applies to condos, co-ops, and homeowner associations across the board. A architectural control can be more limiting, more constricting, more refined and detailed than is the local ordinances, whether city, municipality, county, or even state. What do I mean by that? You can mandate that houses can't be painted pink, even though nothing in Broward County's ordinance says that you can't paint your house pink or purple or gray. You can mandate that houses have a certain color palette, and within that color palette, you cannot paint an approved color palette if the house next to you or across the street from you or even diagonal to you has that same color palette chosen. So while these are not ordinances that are state, county, municipality, city mandated, certainly from an association standpoint, you can have a more restrictive provision or position on this than outside of you with the governmental agency. So why is that important, and how do I tie that into the COVID? A lot of you are calling up now. Your members are dying to use the pool, something I can't blame them. Obviously, we've addressed this and talked about this ad nauseum, and it's something that everybody wants, especially in associations where pool use is either limited to the association's pool, co-op condos, or HOAs that don't have pools in owners' backyards and they use a community pool. Something really important, something that you pay for as part of your assessments, something that you cherish with your kids or your loved ones or yourself personally, just to use and to enjoy on the weekends after a long day at work. Having said that, every association continues to have the right to make mandated rules and regulations regarding use of common areas, common elements that have limitations on their use, notwithstanding what the state of Florida is doing. And let's remember something, and this is, I hate bringing up something that's so tragic, but it's very important, it's poignant to this issue, and it's really relative to this issue. The Parkland massacre, the parents sued, and the Supreme Court of Florida limited their recovery to a nominal amount by contrast to the loss that happened. I believe it's $300,000 or $250,000. There's a few different facets to what their claims are. It wasn't claims for every child. It was claims against, I think, the school, the security, the police, whatever it is. It was a limitation of about $300,000. With the caveat that if they go to the legislature may go ahead and expand that judgment amount or amount that they can get. It's a long process. It's lobbying to get this done. It could take up to 10 years, if not longer, to do so. Why is that important? Why am I bringing that up? If you were to sue the state for COVID death, for issues that are contemplated under that, under COVID, under something to that degree, when you do so, you are limited to that kind of sovereign immunity amounts that the state is obligated to provide to you under statute, under its sovereign immunity. So these potential judgments of millions of dollars, I mean, and think about, again, tie in tragically to Parkland. You're looking at situations at Parkland where you have multiple deaths and yet one cap. So the state of Florida and its municipalities, cities, counties are limited by that sovereign immunity cap to a nominal, relative to what your loss would most likely be, a nominal amount of recovery. And as such, it's extremely important that you understand that for the governor, he's got a couple things he's looking at. He's looking at economics, which obviously we all are concerned about, but he's also looking at exposure, his exposure, and not him personally, but the state of Florida, the municipalities, is capped. Your exposure as a homeowner association, condominium association, or cooperative is not capped. There are no cap laws here for you. We've talked about this in prior instances. You have no insurance. You have absolutely no insurance to cover you. There are riders right now that you can buy where you pay basically to have insurance defense cover you, but those again are insurance defense lawyers who will not pay, the insurance company will not pay the judgment, they'll pay the lawyer's fees. And we've talked about this where odds are the lawyer litigates, and in the end comes back and looks at this and says, you know what, odds are we're not going to win, you got to settle. Thanks for paying the rider on your policy. I've gotten you to this point. I'm hoping that we're going to do well from this. But having said so, at this point, you need to start to settle. And now you're looking, going, wait a minute. We paid all this money for a policy for coverage. Now we don't have. Now we have coverage, but we don't have any money to pay for a judgment, and we're being told we got to pay anyways. What do? Well, we take that and we look at this again in the total picture here. You've got your constituents, your members who want to use your facilities. They're paying for them, they feel they're entitled to them, and to a large degree I completely sympathize, empathize, and understand completely their desire to use it and why they think they should be entitled to do so. Having said that, the board has a duty to the community to preserve and protect, one, the health, welfare, and safety of its members, to whatever degree it's able to do so, and to be prudent in what it does, not exposing the association and its members to litigation unnecessarily. So what do? It's a very difficult proposition. Again, tennis courts, open them up. Basketball courts, I think I've shared with you once before that I'm playing indoors, but I'm mandated to wear a mask. And by the way, nothing has changed at the organization, at the facilities where I play and pay for, that have mandated us not to use a mask just because of phase 3. It is still required. And by the way, even if it wasn't required, again, it's personal choice, and I know it's a personal choice, I would still wear a mask because we don't know. I will note that after Monday's 700-something number of reported cases, today I read that we're up to over 3,500 cases. So it's not going away. There is a second wave that's coming. We're about to enter the fall. I believe it's going to unfortunately get worse, and it's not my belief because I'm some expert on this. It's everything I'm reading from members of the CDC. And yes, Mr. Fauci, Dr. Fauci, whether you love him or hate him or are indifferent to him, I'm reading his updates. I'm looking over what's going on in Europe with numerous countries looking at lockdowns again and a resurgence of COVID-19 throughout. And there's no way we won't experience that. Until that happens, until there's another lockdown, until the governor issues his order again locking down, which again, nobody hopes for, nobody wants, but if it happens, until it happens, what should you do? I discussed in my podcast a little bit about Halloween and the holidays coming up. Really, Halloween's the only one, and other than Christmas and Christmas caroling and so forth, that I can think of where the neighborhoods are exposed. Again, these are not neighborhood sanctioned, mandated events. These more are events that are for personnel, people who are coming to visit, people who live there, and you should make sure and clearly enumerate that either at your security booths, your post-it areas in the community where people know that, look, we want you to all enjoy and be safe during Halloween, during Christmas, during whatever holiday it is, but these are not sanctioned holidays by the association. We're not throwing parties. We're not doing things where we are telling you, come in, enjoy, go around. I know for one, I will not be entertaining people during COVID coming to my house and asking for candy because I simply don't want that interaction. I don't want that interaction with small children where I have to worry about whether my mask is on, whether theirs is on, and I don't want that interaction with people coming in and adults coming in where we're all talking and socializing at close distances, not thinking about what we need to do for protection. So I've left the biggest topic and really my last portion of this, other than opening it up for questions, as to issues regarding the pool and what we do about the pool. From the get-go, I believe that any jacuzzis, any common spas, area spas that people use should be closed. There's just no way to regulate the number of people that go in there and how close they are and whether they're all family, not family, restricting just to family and monitoring and making sure that they use it for 15, 20, 30 minutes and then the next family goes in. Just too difficult. My suggestion is to keep the spa area of your pool free of any person using it and to cordon it off. I still suggest not using furniture. I still suggest having people come either with their own portable chairs or towels and using the facilities that way. I truly believe it's not time yet to bring in furniture where you have to worry about cleaning it. Now, you do have to worry about the fact that the bathrooms have to be opened. The health department will close you down. I've looked into this. I've experienced it with a number of my associations where they have been told specifically by the health department that their pools can be opened, but only with the inclusion of a bathroom being opened if such facility has a bathroom. I still believe that you need to, at a minimum, clean those bathrooms once an hour. Now, if you don't have the money for this, and if you want to take that added risk, and it's a calculated risk, then I think you should post on the doors of the bathrooms signage that I can help you with that basically says that you're using these restrooms at your own risk and that you advise all owners prior to coming to the pool facility to bring their own spray disinfectant and to ensure that they spray before and after they use the facilities, including the handles on both sides, everything within the bathroom facility, including the faucets and so forth that they're using, even the handles for the paper towels, should there be one, or if it's just a pull-down system. That all of it should be sprayed and that each and every one of them needs to assist the association as a whole in ensuring the health, welfare, and safety of themselves, their members, their guests, and invitees, should you allow that. I still think you should mandate masks at the pool. I think you should understand that people in the pool itself do not have to necessarily wear a mask, and that's fine, but that we put the necessary at-risk notices to members. Do we have an added layer of protection now that the governor's opened up to phase 3? Potentially. Again, I think that associations are looked at in a different realm than a state agency. Same thing at a gym. If you went to a gym and the gym wasn't doing its job and you got COVID there, COVID-19 there, and you got sick there, could you sue the gym? Absolutely. Now, gyms, and we've talked about this way in the past, I'll just briefly touch about it, gyms and other such public facilities can make you sign a waiver because your use of their facility can be subject to that waiver, since they have the right to withdraw your right of usage or your membership. Not restaurants, not bars, but gyms. Now, bars, restaurants, I've looked at pictures, and frankly, I think it's horrific. There are people there on top of each other with no masks, celebrating, dancing, socializing. As many of you know or should know, there are a number of schools here in South Florida, Central Florida, and in Tallahassee where the COVID outbreak is tremendous due to just that. Our children, college-age children, socializing, partying, going to bars, going to fraternity, sorority houses, going to parties in general without social distancing, without wearing masks. And the outbreaks are all over the news. So if you're going to open your pool up, let's work on some additional language to let the members know what needs to be done, what the risks are, and that you're doing this based in part on the governor's order, based in part on the fact that you understand that as an adult, they're coming into this and using it at a risk, but you still want to mandate certain things. Now, part of our ability to come off of what we were more stringent before could be based on a lower percentage. Supposedly, we are under 5% of the population being testing positive every day at this point, and that is a safer number that the CDC is saying shows a trend of more normalcy. It does say not to stop using masks, not to stop social distancing, not to stop using, your sprays and cleaning and making sure that you're washing your hands. And that should all be espoused to the owners, the members, their guests and invitees to ensure non-spreading. But having said that, you can a little bit more relax your use of the pool, since many of you don't have the income or the revenue stream of maintenance assessments to pay for ongoing oversight of that, and are either doing it through video cameras or simply through notices that you leave at the pool. But let's be clear about what we leave the owners with signs, what emails, letters that we send them about the usage, about their obligation, about their responsibility to the community, to the other members, and take it from there. I think it also should be noted to them that in the event there is an uptick in cases, and that either phase 2 or, God forbid, hopefully it won't happen, but phase 1 comes back into play, or a total lockdown comes into play, that will happen at the pool itself. Let me finally say this. There is a risk with doing this. There is an absolute risk with doing this. You can have cases, and people, opportunistic people, can come in, get lawyers, and come in and say, hey, we're going to sue the association because you opened up the pool. We don't care what the governor did. We don't care what the bars did. We're not going there. We're still taking care of ourselves, but we trusted you in what you did and what you said, and as a result, we got exposed. And that's the risk you're going to take as an association, and you've got to weigh that. So, one of the questions asked here is, to sum it up, we're okay to open the pool, no furniture, no hot tub, masks required, sign regarding the bathroom use as outlined. Not sure you're saying to allow guests or offsprings. Well, offsprings, children, families of children. That's going to be an issue of what the association can accommodate. If you have the room for that at your pool facilities, yes. If you don't, then you should keep it only to members. As far as opening up the pool, again, I'm saying you can do it, but you need to temper it. You may not be able to have people overseeing you at this point, but you do need to temper it. What if a member fails to comply and leave the facility if told to do so? How should the association handle that? First of all, we're going to find that person, and we're going to let them know that, and this is going to be in the notices. I'm not going into completely what the notices are. We should talk about that. It's a whole conversation separate from this video, but the notices are going to put people on notice that violating this subjects them to fines and legal action. And again, in my podcast of a few weeks ago, I did bring up a case in Miami where a tenant is being sued by the association. It's a commercial building, but because they are not wearing a mask and not complying with their COVID etiquette and standards that the association has put forth. So we would tell that person, again, if you don't leave, we're going to fine you, and if you don't, and in addition to fining you, we're also going to file suit to enjoin you from coming, to stop you from coming to this facility again if you don't leave. You violated it, we're going to let you have a second chance, but at this point you need to understand the consequences. Do we still have social distancing and limit to number of people? Yes. There's nothing different about social distancing. There are people who believe that it's a farce, that it's a political issue. If you're one of those people, then God bless you. That's your right to believe that. I think as an association, you still should mandate social distancing because you want to ensure that people are not on top. The pandemic is not over, right? The spread of this is not done. It's still here. It's still here. It's still going around. There are still new cases, and there's still people dying every day. Limited number of people. I believe banquet halls have now gone to 100 people. So if your association wants to conduct a meeting and has the funds to pay for a facility that can social distance the number of people in your association at a banquet hall, then you're welcome to do that, and you can have your meetings again. If that's cost prohibitive, or you don't see a justification in doing so, then you probably should just continue with the Zoom and postpone until it opens more your elections, your annual meetings. If you want to conduct them by Zoom, if you're small enough to do so and you think you can do that without disenfranchising other members, ensuring that everybody can participate in the action of the election and look at the ballots, look at what's going on, what's been presented, then you should do so as well. A lot of it has to do with your management companies. I know that there are management companies that to this day will not allow, no matter what the governor has ordered, people to come into the facility yet. We at my office do allow you to come in as long as you wear a mask, keep your mask on the entire time, and we social distance. Otherwise, we don't allow people into our facility as well, and we also have a guard against how close you can get to the front desk and talk to our receptionist, because we care about you and about our own people. If the association decides risk is too great and stay closed and owners are upset, do they have recourse to go after the boards? Absolutely, positively not. And I can say that with 100% confidence, and let me tell you why. Boards are protected under Chapter 617, which is the Florida Not-for-Profit Act, that provides specifically that unless a board member is doing something that is criminal or self-serving, which means they profit from it, they cannot be sued individually. And the big case out of in South Florida on this, in the Tri-County area, even though we are divided by Miami-Dade and Broward and Palm Beach, the 4th District Court and the 3rd District Court, but what I think all courts look at and agree with is called the Sonny Boy case. And the Sonny Boy case talks about the fact that you cannot just sue a board member because you feel that they haven't done their job properly. That's not enough. And the reason and the basis for this, and we'll talk about this more in another video, is because of we don't want people being afraid to serve on the board because they'll be sued. Know this, can't be sued unless what you've done is criminal in nature or self-serving, and two, or violates your documents, of course, to some degree. And again, there's some nuances to that we'd have to discuss. And two, we want people to be able to serve on their boards without that fear. And three, your documents provide for indemnification, and that's really the most important part. If you are ever sued as a board member, your documents require that the association pay for your legal expenses, whatever damages and so forth, as long as you are not found to have breached your fiduciary duty by what we've discussed before. Good question. Good. Okay. Something about being the pool police. In effect, we'll be relying on residents to follow guidelines and use common sense. That really is, under my scenario, where you do not have the means, the financial means to provide a monitor. Now that the governor's gone to phase 3, I'm trying to bring that in. It is a risk. I am not telling you that this is foolproof. And again, this video in no means constitutes legal advice. We're having a discussion. Every association is different. Some associations do have video monitoring, have abilities to oversee this. I'm telling you not to stop doing that at least. But this is not, we're not providing legal advice. We're giving opinions here and a discussion. So do I think that absolves you? Absolutely not. Do I think that the governor's phase 3 order now and what the restrictions are that the governor has eased up on help you? Potentially, yes. It's a calculated risk. So, having said that, if you'd like to discuss your association and what your needs are more in more detail, more specifically, please contact me. Happy to sit with you, happy to go and work with you on something that's tailored for your community, and to do so you have something that helps you in a more specific way to address. Everybody's a little bit different. I have some communities who have video oversight and the manager's looking at it. I have other communities that people have roving patrols that come by it, and I have other communities that have none of that and are basically trusting in their members. By the way, some communities I have barely anybody using their pool facilities, and they have no concerns regarding this based on spot checks and ability to see it from the rear of their buildings down into the little enclave there that their condominium surrounds, with the pool being down there. In your opinion, do you think the orders for HOA COAs will be rescinded and or changed to allow use at your own risk? Well, again, it is use at your own risk right now, and while there are orders regarding the CDC and how to apply and how to congregate and so forth, once the CDC removes those orders, I think you're at a much greater leeway to do so. Again, you have your own requirements. It's as if to say, do we have an order out there that says that the tennis courts can't have chips and dips in the asphalt where you run and play? Of course we don't. There's nothing that specifically says a tennis court must have an even surface. We know it does. We know it does, and we know when there's a chip or a dip there and that you can catch your foot on it while playing, that once that's reported to the management company or directly to a board member, that the association's on notice and needs to take care of it, because if you do fall or trip on that and injure yourself, the association could be held liable. So once COVID, and God willing it will be one day soon, sooner rather than later, but once COVID restrictions are lifted or the vaccine is out, yes, we'll be in a situation where you know that if somebody tests positive or comes down with it and acknowledges it, that you tell people, hey, if you were at the pool the other day, you need to get tested, somebody had it, and we're going to, clean down the pool, having not done it for, hopefully at that point weeks or months or at least days, and that we're now doing so. But right now, while Fauci and nobody else from the CDC has said you have an all clear, this is a state-by-state issue where the governor is looking at businesses, looking at the welfare, economic welfare of people in the state, tourists, businesses and so forth. I get that. I think it's a whole different axiom than it is members at an association and what you're doing and how you're handling this. Does it give you a little bit leeway? Yes. Does it absolve you? Absolutely not. This is not like going in and saying a few Hail Marys and everything's good, right? This is serious stuff here that you are still on the hook for. You got a little bit more of a leeway. You got a little bit more of play here that we can talk about individually how it would apply to your community, but in no means does this give an all clear. Nobody's given an all clear. So with that, I will thank you. I'm going to apologize for any delays to getting this going today, and I thank you so much for your patience. And hopefully now with this new software, we'll be good to go and a much cleaner product in the future and more timely. Thank you again. Please remember to subscribe while I am sending out those emails on MailChimp. It's an email service that I have. While I am sending that out to remind you about podcasts and videocasts and giving you those links and so forth, if you subscribe to YouTube, and you can go there directly to my channel, which I provided in emails today, or you can go to our website, www.shirlawgroup.com/media, and go up into the upper right-hand corner and click on the YouTube link. If you subscribe, you will automatically be notified of when a video is being dropped, either new or live, and be able to participate. Thank you again. Be well, be safe, and all the best.